chapter 13, part 4. Okay, so we're up to discharge by performance, and we're talking about the time in which the parties have to perform. And you may have read a contract before where it has the language, time is of the essence. And that's an important condition in a contract because of what we have up here. If the contract doesn't state the time for performance, then the law requires that it be done within a reasonable time. That's what's implied. If a specific time is stated, though, the parties usually have to comply with the actions or what they've promised to do within that time. So unless the time is expressly stated as vital, that is, time is of the essence, a performance delay will not usually destroy the performing party's right to payment. Alright, so now let's move on to discharge by agreement. This is a situation where perhaps the contract has not been fully performed, but the parties agree to discharge one another. Okay, so you can have discharge by what's called mutual rescission. This is where both parties agree to terminate the contract and under what terms they're going to terminate the contract at that point. So the parties must make another agreement that also satisfies the requirements of a contract. In other words, they have to have the offer and acceptance and consideration. So rescission of most executory contracts, that is, contracts that have not been completed, is enforceable if the agreement is made orally or even if the original contract was in writing. Now we also have what's called a discharge by novation. This is the substitution of a new third party for one of the original parties. The requirements for a novation are a previous valid obligation, an agreement by all parties, extinguishment of all old obligations, and a new valid contract. So this would be a situation, for example, in the case or scenario I gave you before. You hired somebody to build, in addition to your house, add a room onto your house. Halfway through the completion, the person wants to get out from under the contract, and so they come to you and say, look, I need to move on to another project I have that is compelling, but my friend who also is a contractor is willing to complete the performance of this, and we've agreed on how to divide the contract price, etc. And you learn that this person who's going to complete it is a satisfactory worker, so you agree to it. You enter into a new valid contract. So there is what's called a novation. So the novation impliedly or expressly revokes the previous contract. A different situation is discharge by a settlement agreement. This is a situation where it's not necessarily a third person stepping in to perform the remaining parts of the contract. This is a situation where you have the parties deciding they want to stop the execution of the contract, and they reach some sort of settlement agreement, usually with consideration passing from each side to the other. Then there's what's called an accord and satisfaction. This is a situation where you have what's called the accord, which is a contract to perform an existing contractual duty that's not yet been discharged. But the parties enter into an agreement not to go forward with the contract, and there is a satisfaction that has been made. Usually with an accord and satisfaction, the law requires that there be some dispute between the parties. And in order to resolve that dispute, the parties enter into the accord and satisfaction, which is an agreement to rectify that disagreement in some way and enter into a new contract. Okay, now how else can you have a discharge of the contractual obligations of the parties? Well, you can have a material alteration of the contract, which is where one of the parties has basically whited out or somehow changed the terms of the contract. The law will then call the contract to an end, and the party who has been harmed can seek appropriate remedies. Where you have a breach of contract, you have to file your lawsuit, of course, within the statute of limitations. And this may get into issues of when the contract was actually breached, because it's the breach of the contract that usually triggers the statute of limitations. One of the parties filing a bankruptcy can also result in the discharge of the contract, and then the bankruptcy court will deal with the damage issues and whether or not either party is compensated. Impossibility of performance is when there's a supervening event that makes performance objectively impossible. This applies only if that event was not foreseeable. So if you enter into a contract to buy somebody's car, you sign the paperwork, and then an airplane falls out of the sky and hits the car, and the car is totaled, there's impossibility of performance in that situation. So objective impossibility, which is it can't be done, has to be distinguished from subjective impossibility. I simply cannot do it. Okay. So what are some of the situations that can allow for discharge of contractual obligations based on impossibility? One party to a personal contract dies or becomes incapacitated prior to performance. Notice that it has to be a personal contract. So you're hiring somebody to sing at your wedding, and it's somebody that is very unique, and it's a personal contract. In other words, you're not just hiring a company to provide a singer at your wedding, you're hiring a particular individual. If that person dies or becomes incapacitated, then you have a discharge of the contract. Or if the subject matter of the contract is destroyed, like the automobile we talked about before. Or you may have a situation where the subject matter of the contract becomes illegal, and you can no longer do it. Where you have a temporary impossibility, performance is usually only delayed. Once the event ends, the parties must perform the contract as originally planned. You might have a lot of these situations currently with the coronavirus, where people have entered into contracts and cannot continue performing them until after the restrictions on our lives have been lifted by the government. In those situations, generally, you're not going to have discharge of the obligations. You're only going to have a temporary impossibility in which the performance obligations are picked back up again once the restrictions are lifted. Okay. Another situation is discharge by operation of law. For example, commercial impracticability. Parties can be excused from the contract and performance of the contract when it becomes more difficult or expensive than the parties originally expected at the contract formation. So, for example, if you contracted to build a building on some land, and part of the building was to dig into the ground and build a sufficient foundation, and then it turns out that there's a certain type of rock in the land that was not known by either party, and the cost of removing that rock would be greater than the contract itself, that would create a commercial impracticability.